Hi, I'm Jonathan Kappy.
And I'm Ashley Naipaul.
Welcome to Holland Estates. You're listening to episode number 634. Today we are going to be discussing the Mac and Mac decision. First of all, how you doing, Ashley?
I'm good. How are you?
Good. This is your first podcast. I'm very excited.
I am too. It's a nice day today, so that adds to it.
It is. So today we are going to be discussing the Mac decision. The Mac decision deals with a lot of different issues. I think that we are going to sort of focus on the RRIF issue because this decision came out following the Kalmusky decision and really takes the court down a different road. And I think for general people who practice in this area, this is something that we hope was coming. So why don't we talk about it? We'll get into it. But Ashley, why don't you start by giving us an overview of the facts?
Definitely. In this case, we're dealing with a family dispute, unfortunately, which is quite common in estate matters. The family consisted of the father, mother, and 4 sons, Raymond, Eddie, Steve, and Kenny. As you mentioned, this case deals with a lot of disputed properties and assets, which, the court addressed with tracing the funds back and that sort of thing, but we'll focus on the facts associated with the RRIF designation. But all of this sort of began when the parents executed their wills in 1994, and each spouse left property to the other, and the estate of the surviving spouse was to be split equally between the 4 sons. In 2002, the father passed away, and in July 2007, the mother had named one of her sons, Kenny, as a designated beneficiary to her RRIF account. In March 2012, the mother went to see a neurologist, and it was noted at the time that she had memory problems for about a year prior to her visit, and she was diagnosed with dementia at the time. In July 2012, her condition unfortunately got worse, and then she passed away in November 19th, 2015. And her other son, Raymond, started acting as the estate trustee. So essentially in this case, there was a dispute specifically about the RRIF designation. The plaintiffs in this case were the mother's estate, Raymond, Eddie, and Steve, and the defendant was Kenny. And essentially, the plaintiffs wanted an order setting aside the beneficiary designation, naming Kenny as a beneficiary on the basis of undue influence. And they also made an argument that the RRIF was held in trust for the estate through the concept of presumption of resulting trust.
Right. So that's where we get into, the interesting part. So we start off with Kalmusky. Right, and so Kalmusky was a decision in which it was also a beneficiary designation, and what the court did in that particular case was it started its analysis with PCOR, right? And we all know that PCOR, in dealing with jointly held assets and the right of survivorship, talks about the presumption of a resulting trust when those assets are held jointly with adult children. Okay, and so the court in Kalmusky stretched that analysis to include beneficiary designations, to say that where you are the beneficiary of a policy, you are also presumed to be holding that on a resulting trust in favor of the estate, that there was no clear intention that it go to you, only that you are holding it on a resulting trust unless you can overcome that presumption. That got the legal community into some debate. Some people didn't like it. Some people didn't like the fact that that analysis was stretched beyond perhaps what was originally intended. There were a number of decisions, I think a couple, I think there was one in Manitoba as well, that came out that followed along the same analysis as Kalmusky. And this is really the first time where the court goes the other way and draws a distinction between what PCOR intended and RRIFs and other Section 50 plans, things that have designated beneficiaries. So this is absolutely about whether or not, number one, there was undue influence, and we can get through that very quickly. The court very quickly says, listen, there does not appear to be any evidence of undue influence, and it's all speculation. Well, one of the issues that arises in the context of the analysis in dealing with undue influence is something that what was called the presumption of undue influence. Okay, And there's a series of cases, Seguin is one of the cases, Seguin and Pearson, that talk about the presumption of undue influence in the context of inter vivos gifts given by someone to someone else where they're in a position to influence them. Another similar concept is called unconscionable procurement. Okay, and so there is a legal presumption in the case of inter vivos gifts that if you are in a position to influence them and to dominate them, that perhaps the court should start with the analysis of, yes, we're going to assume that there is undue influence unless you can show that there's not. But what the court in this case did was it said, listen, we're not talking about an inter vivos gift. We were talking about a designation of a beneficiary in a RRIF that is not inter vivos, that is testamentary. And the analysis with respect to presumption on an inter vivos gift doesn't apply. And so, in fact, the onus is not on the recipient, it's on the person who is trying to assert the undue influence. So that's sort of the first part of the analysis that the court goes through. And then the next part of the case, it talks about, no, we are not going to regard there as being a presumption of resulting trust. The court definitely goes straight to PCOR, and it talks about PCOR and the designation of beneficiaries, and it says that they are not the same. Having a joint account with somebody and designating someone as a beneficiary of an account are very different circumstances. And to give the judge credit, the judge went right to Cal Muskie and said, listen, there is reason to doubt the correctness of that decision for two main reasons. The first one, the presumption in PCOR is also dealing with inter vivos gifts. The designation of a beneficiary in a RRIF is not an inter vivos gift. It is testamentary in nature, and the analysis is simply not the same. And listen, the judge also says, listen, Cal Muskie has been the subject of much criticism since it came out. And so the judge also felt that there was justification within the community, and the arguments that were raised as to why Cal Muskie was wrongly decided to change it. And in fact, the judge refers to an article that was written, and in particular referring to the legislation. I mean, there is a huge distinction between a jointly held bank account and a plan that designates a beneficiary in accordance with the statute, right? I mean, Section 51 sub 1 of the Succession Law Reform Act says that an individual can designate a beneficiary of a plan. And it says under Section 53 that the administration of a plan must pay out in accordance with the beneficiary designation. So this is not some common law, presumption as between co-owners. This is someone who is designating a beneficiary in accordance with the statute. The person administering the plan must pay it out to that beneficiary, and it's very different than PCOR, very different than inter vivos gifts, and very different than jointly held property. And so that's, and so that brings us back, I think, to where we all expected things were before Cal Muskie. And we sort of went a roundabout way of getting there, but we now have the clarification. I do think that since this decision came out, there has been a similar decision that has come out with respect to other types of beneficiary designations beyond just a RRIF. I think it might have been an RRSP case that came out. Something along similar lines, but not, so, it seems to be now that the courts are accepting that all of these plans that have beneficiary designations are now not governed by the core presumption of resulting trust, but do actually go to their beneficiary. Unless, of course, you can't show that there was lack of capacity, there was undue influence, all those other things that relate to testamentary gifts. So, I think we sort of covered it. I think it's a great case. I think it does the analysis right, and it brings us back to where I think the profession believes that we should be. And I think that concludes our podcast for today. So until next time, we want to thank you for listening. I'm Jonathon Kappy.
I'm Ashley Naipaul.
Should you have any questions, please email us at info@hollandhall.com or contact us through the contact page on our website. Have a great day.